Good afternoon or good morning, dear participants. Welcome to our webinar, Protecting Investors' Rights with World-Class Dispute Resolution at the AIFC Court and the International Arbitration Center. I think it is the most important topic for investors and we're ready to discuss it now. Our speaker is Christopher Campbell-Holt, the Registrar and Chief Executive of the AIFC Court and the International Arbitration Center. Chris will present the excellent opportunities that these organizations can offer to protect investors' rights. After the speech, we're going to have Q&A session. Please feel free to write your questions in Q&A chat box at the bottom of the screen. Добрый день или доброе утро, уважаемые участники. Мы рады приветствовать вас на вебинаре.
Good afternoon or good morning, dear participants. We will now talk about protecting investor rights, and our speaker is Christopher Campbell-Holt, who is the Registrar and Chief Executive of the AIFC Court and International Arbitration Center. This will be followed by a Q&A session, so you may write your comments and questions in the chat box.
Thank you very much, Asel, and thank you very much to AFSA and the organisers of this important World Investor Week. It's my great honour and privilege to speak to you all today. What I'm going to do is start by introducing on the topic of protecting investor rights at the AIFC through the AIFC Court and the IAC, or IAC as we call it, the International Arbitration Center, based at the Astana International Financial Center, the AIFC. I'm then going to mention a few examples of case statistics and some of our initiatives, and then take some questions. So to start with, I'd like to introduce myself. I'm the Registrar and Chief Executive of the Court and the Arbitration Centre, with the first Chief Justice of the AIFC Court, Lord Wolfe, the former Lord Chief Justice of England and Wales, and the support of the AIFC Governor's team, Dr. Karik Kalembatov. We created a truly world-class dispute resolution premises and facility for all investors, not just investors coming to the AIFC, but of course we hope and expect that AIFC investors will use our court and arbitration centre. Indeed, they are already, as I'll explain a bit later in this presentation. But we want all investors coming to Kazakhstan, indeed the entire Eurasia region, to have their rights as investors protected, applying the very highest international standards of independence, impartiality, absolute incorruptibility, and applying the highest, most strictest standards, the international standards of the rule of law. This is really important. Why? Because all investors, anyone having a legal right or relationship, wants to know, I hope, that they have rights, and those rights are guaranteed to be protected. They will be treated fairly, they will be treated equally, and above all, the highest standards of the rule of law will be complied with in every single case without exception. The Court and Arbitration Centre became operational with effect from the 1st of January 2018. As such, we are now coming towards the end of our 4th year of operations. Considerable development and progress, and indeed casework, has now happened at our Court and Arbitration Centre. Why do we have a court and an arbitration centre? Often international financial centres, particularly new international financial centres, will have just a court, a common law court, increasingly, if you look at examples from the Middle East and from Asia in particular. Or they will have an international arbitration centre. Perhaps they'll set that up and run that independently as a standalone international arbitration centre of their own in that host country, or they'll partner with perhaps well-established, well-known and trusted international arbitration centres from other parts of the world, perhaps from Singapore or London. But what we did in Kazakhstan was to create an absolutely world-class commercial and civil law court, a court of law, which applies the very highest and most up-to-date common law procedures, taken, I suppose, from the English and Welsh legal system, but also improved upon with the very highest international best practice standards. We created an international arbitration centre as a separate independent legal entity from the court, and together both of those entities provide a one-stop shop for international standard commercial dispute resolution, all within mind of protecting you, the investors, in the most appropriate international way, complying with the rule of law. The court is chaired by its Chief Justice. The Chief Justice of the AIFC Court is Lord Mance, the former Deputy President of the United Kingdom Supreme Court. And that's Lord Mance. Before Lord Mance, we had Lord Wolfe, who I mentioned previously, who, with myself and others, set up the Court and Arbitration Centre some years ago. And the other judges comprise some of the most respected and trusted judges from the English and Welsh system, all of whom have international standard experience, firstly as lawyers and now secondly as judges, and in some cases as arbitrators and mediators. Those judges include recently retired members of the Court of Appeal from the English and Welsh judicial system. And a number of those judges, in fact, I think all of the judges, are now actively working on arbitration disputes as arbitrators in addition to their judicial duties and work. The Arbitration Centre is chaired by Barbara Doman QC. She has been our first and still continues to be our chairman of the IAC. She has more than 40 years' experience as a commercial litigator. Again, she's world renowned for her reputation as a litigator, arbitrator, and also as a mediator. We could not be more fortunate to be led by the people that we have. Supporting the Arbitration Centre is a world-class panel of arbitrators and mediators consisting of some of the most respected and trusted names in the arbitration and mediation world internationally and regionally and locally in Kazakhstan. This is really important, and I raise this for all investors because what we want to build through our AIFC, but specifically through our dispute resolution, investor rights protection, if you like, is trust and confidence from you, the investors. Why would you want to invest into a country or into a project, for example, if you do not perhaps understand the system in play that is applicable for your business or legal relationship with the people you are investing with? If you do not know or have any confidence that you can and always will be treated fairly and independently with a properly set up international standard justice system, you will for sure receive that. The Constitution of Kazakhstan was amended before the AIFC became fully operational back in, I think, 2018 to effect a proper legal system that is independent of the judicial and legal system otherwise of the Republic of Kazakhstan. It's a similar system to what one might be familiar with from, say, Dubai or Qatar or to some extent Abu Dhabi, but it's now in Kazakhstan for the first time in Central Asia, indeed for the first time in the entire Eurasia region. The Court and Arbitration Centre have specific powers and jurisdiction. Now, in my experience, and I've been doing this for a number of years, previously in the Middle East in Qatar and in one or two other places from time to time in different ways. But we decided for Kazakhstan that the court, the AIFC Court, applying, as I said, common law procedure and international best practice, would have a very open, wide jurisdiction. So, of course, the court exists to help parties resolve fairly and equally applying the highest international standards of the rule of law, commercial or civil disputes in relation to any business practices operating within the AIFC. All right, very similar to what you might find, or you do find in Dubai and Qatar and the ADGM in Abu Dhabi. But we've gone further than that. And we have provided a much wider so-called opt-in jurisdiction to our court. So parties can apply, in theory, any law they wish to apply. It doesn't just have to be AIFC law, which we increasingly handle at our courts and see coming through our doors on a regular basis through the various cases, both actually at the court and the arbitration centre. But parties can now apply any law that they wish as long as they agree in writing, subject, of course, to the court, which means one judge at court of first instance, acknowledging or giving jurisdiction for that particular dispute. At the arbitration centre, parties can apply any law that they have agreed in writing, as long as the parties agree in writing, similar to the practices at the perhaps London Court of International Arbitration or the Singapore Centre or other world-renowned international arbitration centres. It's very similar for us in the AIFC in Kazakhstan at our arbitration centre. You can apply any law with the parties in written agreement together. You can apply at the arbitration centre any procedural rules. You don't have to use our rules. We warmly encourage parties in dispute at our arbitration centre to use our arbitration and mediation rules, and many parties have done successfully. But you don't have to. Parties can apply the UNCITRAL rules if they wish to do so, or if they're obliged to do so. And indeed, they can also apply any ad hoc rules. So any rules effectively the parties agree in writing they want to apply, they can apply. In the arbitration centre, if the seat is not clear, then the AIFC arbitration regulations will be the default seat unless the parties agree otherwise in writing. That has been proven in practice already in arbitration proceedings at the IAC. So what I want to emphasise in terms of the powers, the jurisdiction of the Court and Arbitration Centre is that they both really are open for all business people, all commercial entities or commercial people to come to us to resolve their disputes. Now, there are some cases where parties want to use a court. They want to go to court, perhaps because, and of course the reasons are different in every specific case, but sometimes the reason might be that the parties want the public to be able to attend the hearings. They want the public to see justice being done. They want to make a public statement. They want to see a judgment. In our case, we provide our judgments free of charge, accessible 24/7 from our AIFC Court website in the languages in English, Russian and Kazakhstan languages. And we want these judgments to be seen, to be analysed, to be commented upon, to form some body, if you like, of precedent, which is more familiar in a common law legal system. And that's happening. We currently have, I understand, 17 judgments and orders on our AIFC Court website, and they should be available in English, Russian and Kazakh languages. Sometimes parties don't want the public to know their business. Perhaps there are secrets, business secrets. Perhaps they just don't want to suffer any potential negative reputational harm publicly. So they often will and are seeking assistance from our AIFC dispute resolution entities with arbitration, and increasingly and mostly actually in practice through mediation. Now, arbitration has proven to be a successful dispute resolution practice. Indeed, so has mediation in various forms for, well, probably thousands of years in different forms. Well, we now have the very highest standards applying a court litigation system with judicial mediation supporting that, and then a separate independent arbitration centre providing arbitration, mediation, and other forms of alternative dispute resolution methods. In other words, alternative to going to court in the more traditional sense. Both the Court and IAC, at the front of our minds when we created the Court and IAC, was enforcement. What is the point going to all the time and trouble of bringing a dispute to commercial dispute resolution at our court or arbitration centre if at the end of the process you don't get paid, or one party who wins money, for example, under a judgment or order doesn't get paid? Well, we've sorted that in practice. So through our regulations and our rules, and then followed up with our policies and internal procedures, we have achieved the following. When an arbitration award is given at the IAC, whether it's an interim or a final arbitration award, parties are at liberty to bring an application to the AIFC Court for recognition and enforcement. And this has happened at least on 4 occasions where judgments and orders have now been given by the AIFC Court, firstly to recognise and secondly to enforce, subject to a later execution order, which goes out in my name as the enforcement judge of the AIFC Court in Russian and Kazakh languages to the authorities in Kazakhstan for immediate or very swift, certainly, enforcement. The court, when it needs to have its own judgments enforced, does that simply through an execution order in a way that one would be familiar from any court, I hope, in the world. What we have done is create an enforcement system within the entire territory of Kazakhstan, not just within the geography and territory of the AIFC, but throughout the entire territory of the entire Republic of Kazakhstan, which, for anyone who's not that familiar with Kazakhstan, is an enormous geographical size. Some say of comparisons to the size of Western Europe. It's an enormous country with multiple regions of businesses and industry and economic zones dotted throughout the country. So it's very important that we do have those enforcement powers. And we are using them effectively with the support of the parties in dispute. One aspect I want to highlight on enforcement is that the local courts of Kazakhstan do not have a direct role to play with enforcement. The AIFC Court and Arbitration Centre, as I said at the outset of these remarks, are 100% independent. No one has authority anywhere in Kazakhstan or elsewhere to review or supervise the work of the court or the arbitration centre. And that's been proven in practice during certainly the last 4 years while I've been registrar and chief executive and enforcement judge at the AIFC Court. There's been absolutely no interference or even attempt at that. It's been absolutely respected and trusted as being independent and impartial. The premises that we have, the facilities that we have at the Court and IAC are top international standard. For anyone who's familiar with the Expo site in the Sultan, the capital city of Kazakhstan, I hope if you haven't already visited, you will do so at the nearest opportunity and you will be immediately impressed. You'll be impressed because the physical premises really are the highest international standards. We have a first-rate IT, modernly equipped court hearing room with all the latest digital technology that is required these days for international dispute resolution at the highest standards. We have a similar facility for the Arbitration Centre, the Arbitration Centre hearing room. We have a world-class lecture facility, which is used often for training facilities and other purposes. We have a suite of meeting rooms called the AIFC Court and IAC chambers. Some of you will be familiar, if not all of you, with the Maxwell Chambers model and the IDRC model from London. The Maxwell Chambers is in Singapore and the IDC in London. Those two, in my experience, form good examples of what can be achieved with the physical and IT facilities that are on offer for lawyers and parties using dispute resolution. And ours are absolutely first-rate, top international quality. We have everything. I think we have 8 or more meeting rooms, all equipped with technology, with all the latest facilities, with secure document management, electronically and in person. We give you, the parties, a secure room and only you have the key. No one else has access to that room for the time that you are using our physical premises. We have a client services program where we provide additional support for lawyers, so everything down to visa assistance, hotel discounts, translation facilities, access to live transcription on camera, access to recordings of hearings, which provided you're a party, of course, in the case, and it's all approved by the arbitrator or the judge administering the dispute proceedings. We provide access to catering, the full facilities that any lawyer or party might need or will need when they get off that plane physically to come to our premises for a hearing. Now, if that's not good enough, then what we provide is 100% IT infrastructure. So we have e-justice. This was developed with our friends from Singapore, Crimson Logic. We launched this back, I think, in February 2019, and we've been using it ever since on a limited number of cases at the discretion of the parties. We do not force parties to use digital technology. We provide a platform in every possible sense of access to justice where we invite the parties at their decision and a mutual decision to use whichever facilities they wish to use, including the rules and the regulations, to support their aspirations of adequate dispute resolution applying international standards. So e-justice provides a secure database where all documents are filed, and they can be done. That can be done, and it is being done 24/7, free of charge for the time being. And the judges have access, and arbitrators have access to those papers where necessary. It's all secure with secure personal identification codes, similar to what we're all familiar with other media areas or internet areas, if you like, of our lives. And we provide thorough training. We've done this. We've rolled out training over the recent years to a lot of people within Kazakhstan and internationally through the online platform. And we are always available to provide assistance, not just with training, but also with maintenance matters, which we all know come up from time to time during the course of online dispute resolution. Well, actually, in our case, it's very, very rare. I suppose, given the modern status and the technical competence of the company that has worked with us to develop our e-justice platform. But if and when we do have problems, we're able to resolve those disputes very quickly and effectively. We do not simply refer parties to a maintenance provider in another country. We do it ourselves with the maintenance provider. So the point of contact for parties is always the excellent AIFC Court or IAC registry staff, so that all of your matters, whatever they may be, your concerns, will be dealt with swiftly and cost effectively to suit your needs. In terms of casework, often when one looks at the statistics, and it's never great to keep talking about statistics, but I do think in the early stages of the development of an international common law court, or any court, an arbitration centre, it is important to provide a flavour, if you like, of the user function. How often is the centre being used? And that is not necessarily to say that it's the best in the world, which is not what we're trying to say, but it is a reflection or an indication of the trust and confidence that the community, whether it's local, regional, or in our case international, has given your facility and are therefore using it. So far, our Court and Arbitration Centre collectively have resolved a total of 731 cases to final, from initial request if it's an arbitration or mediation or formal claim form initiation if it's at the court, all the way through to final disposition, including in some cases, but not necessarily all, because remember, we do encourage parties to enforce their judgments or arbitration rules voluntarily, and if that fails, they can then come to the court for support, and that is what's happening in practice. But 731 cases have now been successfully resolved to final resolution. And that has involved all manner of types of disputes so far. So it's involved, of course, applications coming to the Court of First Instance, which has one judge sitting typically. It can have more, but typically it's one judge in the court. And then if a party is not satisfied for whatever reason on that judgment or order that has been given by the judge at Court of First Instance, the parties have a right to apply for permission to appeal. There's no automatic right for appeal, but a right to apply for permission to appeal to a judge or judges at the AIFC Court. And that power has been exercised at least on one occasion that I can recollect now, and successfully, although the permission to appeal was not granted in that case. And then there was a subsequent permission to appeal application, which of course was not permitted under the rules. So that was swiftly dealt with by one of our most senior judges in that dispute. The court has dealt with, and the Arbitration Centre have dealt with all manner of commercial disputes so far across that wide number of 731 cases. Those cases have included classically, or typically, I should say, contract disputes, so non-payment under those contracts or non-delivery of other obligations other than payments under those contracts. We've dealt with, and we're continually dealing with, ongoing cases at the Court and Arbitration Centre involving construction matters. You're all aware that a lot of investments in Kazakhstan involve construction projects, and the AIFC Court and IAC are continuously dealing with a number of construction disputes, both at the court and the arbitration centre. Disputes also have involved matters of finance, even related to family disputes, the financial aspects of those family disputes, particularly at the arbitration centre, not the court at this stage, but general financial matters, so facility agreements, banking, loan arrangements and the like have been dealt with by our facility for dispute resolution at the AIFC. Land and property disputes have been dealt with, and the laws that have applied have been chiefly AIFC laws, which, if you're not aware, are initially were based on the principles and norms of the English common law, but I prefer to say more the general common law, because I think it's not right necessarily in the modern business world to talk just about English common law, as tempting as it is to do as a British person, or an English person, I should say. But it is really the common law, and it's been codified in a similar way to what one's familiar with in Dubai and Qatar, and to some extent in Abu Dhabi at the ADGM. And that is a series of codified laws or acts known as the acting law of the AIFC. The AIFC Acts is the formal official term for AIFC laws, and it's a collection of international standard common law, albeit in a codified form, and applying international best practice as well, laws comprising contracts regulations or laws, companies laws, employment laws, and various other laws which are critically important to enable businesses to successfully invest and manage their business or investment relationships with their parties subject to that investment. And then, of course, hopefully it won't be necessary, because of course we don't encourage disputes, but we are here if there are disputes. And unfortunately, in most business or investment contexts, there will be scope for disputes or misunderstandings for whatever reasons. And we all know that, which is why we have our world-class AIFC Court and International Arbitration Centre. I'm happy to inform you that this Court and Arbitration Centre are not just here for Kazakh people in Kazakhstan. We're an international financial center, and we're looking for investments from everywhere, but specifically from the region of Kazakhstan, not just Kazakhstan. So that means the whole of Central Asia and Eurasia and beyond internationally. And the evidence is there already in the user function, or the way the Court and Arbitration Centre has been used already. We have had parties in disputes at the Court and Arbitration Centre from a total of, I believe it's 16 countries. A lot of the parties, of course, have been Kazakh or Kazakh nationality, but the assets in those disputes have not just been in Kazakhstan, they've been in some cases all around the world. Those countries, I won't read all of them out, but they have included parties from the United Kingdom, parties from Canada, parties from India, throughout the BRI, the Belt and Road Initiative countries, of course, China, Russia, throughout the Central Asia and Eurasia region, including from countries such as the Ukraine, Belgium, Italy, from Europe, and many, many other countries, including Uzbekistan, the Kyrgyz Republic, and many other countries I won't mention now. But just to give you an indication of the reach, the access to this court, it really has been now 16 countries represented, or parties from those countries representing investments at our Court and Arbitration Centre. And 13 of those 16 countries have been countries from the BRI Initiative countries, so the Belt and Road Initiative. All of those cases where the parties have not voluntarily enforced under the arbitration award or the mediation settlement agreement or the judgment or order of the AIFC Court have been enforced by the court where necessary, by application of the parties, so far to 100% satisfaction. Now, this is, of course, an area in which the court will be tested throughout its life, but so far the success stories have been there, and everything has been enforced where it's been necessary. The court provides a uniquely supervisory function. It doesn't just give an execution order and a judgment and order for enforcement. What it does not take the role of the bailiffs, but it works very cooperatively and closely in a very close cooperation with the private centre for bailiffs for enforcing against private assets located anywhere within the territory of Kazakhstan, and secondly with the Ministry of Justice of Kazakhstan, where that enforcement requires enforcement against Kazakhstan's state assets. The court signed, through its first Chief Justice, Lord Wolf, a memoranda of understanding or cooperation agreements with both of these enforcement authorities for private and state assets enforcement in Kazakhstan. And so far, as I've just mentioned, the enforcement has been successful. What is unique to us in some regards compared to other courts is that while we are not bailiffs and while we do not engage the local courts at all, we are completely independent, including with regards to enforcement of AIFC Court judgments and orders in the Republic of Kazakhstan, is that we do have a very close supervisory role subject to these memoranda of understanding that I just mentioned with the enforcement authorities in Kazakhstan. And what that means in practice is that we are regularly in close contact daily with the enforcement agents directly on behalf of parties or with the parties at the parties' discretion. Parties can do this, of course, on their own if they wish to do so. But if they wish to seek our support, then we are there to hold their hands, if you like, to enable a better relationship and hopefully quicker and more cost-effective enforcement of those AIFC Court judgments and orders, and also, of course, the interim and final arbitration awards of our arbitration centre, albeit converted into enforcement execution orders at the AIFC Court. The court engages internationally in many regards, but specifically on enforcement. We have reciprocal understandings in place with numerous countries around the world through our membership of the SIFOC, the Standing International Forum of Commercial Courts, and we work cooperatively on a reciprocal basis with various jurisdictions within the more than 40 jurisdictions around the world that are represented through that membership of this group. We meet once a year and we share ideas. It's specifically membership for chief justices and registrars or chief executives of courts, commercial courts specifically, and others where permitted by the institution. And it's a very effective medium for us to share as a court our ideas, our strategies, our planning, our thoughts on key topical matters, and to work cooperatively with these other courts. So we are very fortunate that we have this amazing relationship and infrastructure in place to ensure the greatest chances of success in adequately and internationally protecting investor rights through our court and arbitration centre. I haven't mentioned fees yet. Now, this is a critical feature for a lot of parties, for some parties more than others, depending on the complexity or the otherwise of the dispute that is there to be resolved. But our fees are zero for the time being. We've set this, of course, we are new institutions, relatively new, as we're approaching the end of our 4th year of AIFC Court and IAC operations. We will be introducing extremely low fees, I should add, from the 1st of January 2022, so next year, and we're doing that because we recognise that we are now being used a lot by international, local and regional investors who now trust us, and we feel it's appropriate to introduce, similar to other centres around the world and indeed within Kazakhstan, a small fee. But I can assure everyone that fee will be subject to a proper consultation with the community and our users committee, and we're working to that effect already. And we will be publishing those fees in the coming months, excuse me, once we have completed that consultation exercise. But rest assured, the fees will be absolutely minimum and lower than what is already charged in the local dispute resolution institutions, including the courts within Kazakhstan. There are various initiatives which I want to highlight, which are a part of our growing awareness, if you like, and growing development at the highest international level. Now, a lot of arbitration centres and commercial courts talk about international rule of law standards, and they have jurisdiction, they have the right judges, or the right training programs, the right enforcement mechanisms, the right rules. We have all of that at the AIFC in Kazakhstan to provide absolute first-class international commercial dispute resolution protection of investor rights. But in addition, there are other matters which perhaps some centres focus too much energy on or too little energy. Well, we hope we get the balance right in the AIFC in Kazakhstan. And that is, we've just signed through our chairman, Barbara Domin-QC of the IAC, the pledge, which is appropriate for arbitration and alternative dispute resolution practices in particular. And this is, if anyone doesn't know, a commitment to increased promotions of diversity within dispute resolution procedures and practices on an everyday level. We already respect the number of women who are representative of our arbitrator panel, and indeed so far we would say, I think that the figures have been roughly 50-50, 50% men, 50% women roughly, across our arbitration proceedings. We have one judge at the court who's a woman. We hope in due course at the appropriate time to have more women to bring that balance up, and this is to satisfy increasingly the options of parties coming to disputes, that if they wish to have a woman or a man, they can have both or one or the other. That facility is there. Now, other initiatives include, I just mentioned the BRI initiative. So we have access to all of our facilities, of course, not just for everyone, but specifically with specific programs where relevant and necessary for parties that are coming from the Belt and Road Initiative countries. So far I've said that's 13 countries out of the 16 that have been represented in cases at our court and arbitration centre. That's all I wanted to say by way of an introduction, and I hand over now to some questions.
Thank you, Chris, for your speech. And we have several questions, which I'm going to ask you now. The first question is about case management work at the AIFC. How does case management work at the AIFC court?
So case management works in various ways. The first place that parties often will become aware of the case management department in a court is when they file their actual claim. So we have a claim form which is issued to parties. We try to adopt a very supportive function of the registry. We're not there to take the role of lawyers to complete forms or anything like that, but we do provide an international standard query desk, if you like, where parties are able to approach the registry for some limited procedural guidance, if you like, on how the best way is to complete the documentation that's necessary. The case management department then review all papers that come in that are submitted or filed at the court. And it's the same for the arbitration centre, albeit we have different names. It's called a claim form for the court, a request for arbitration at the arbitration centre. And the job of the case management department is to review those documents and to ensure that everything is there that the judge or the arbitrator requires to consider and therefore make a decision on the dispute. The case management department also takes on interns. It has a role that contributes, if you like, to society. And we tend to recruit as many of our interns as we can, the very, very best interns. And they're all Kazakh nationals or from increasingly from other parts of the world. We had some Indian representatives from Delhi, I think, recently. So it's a very important part of any dispute resolution business, in addition to the other aspects of what we do.
Thank you, Chris. Second question about caseload. If you are to attract significant number of cases, how are you going to cope? What is your capacity to deal adequately at the international standards with those cases?
Well, it depends how you approach this question. So my view is we've already done it. I mean, 731 cases across a new common law international commercial court and an international arbitration centre is exceptional. I can't think of any other courts like ours that have had so many cases so quickly. It's 17 judgments on the website, and there are ongoing cases in litigation right now, both at the court and with arbitration and mediation at the arbitration centre. So we are pleased, I think is the right word, by that growth. But we want more, of course. We're here to meet the requirements for dispute resolution of all investors, whether they're in Kazakhstan or anywhere else in the region, or in fact globally, if they have good cause or reason to want to use our facilities. And some do, as I touched upon in my opening remarks. But yes, there are various efforts that we place. We're not here, I have to say this from the outset again, we are not here to encourage disputes. Of course we're not. That's not in the interest of justice. We're here to support parties who find themselves, for whatever reason, in a dispute, to have the best possible facilities, best possible IT, best possible rules and personnel to ensure that their dispute is considered and resolved fairly and equally with absolute independence and impartiality. As I said before, with no corruption or any suggestion of that, and applying the highest international standards of the rule of law. So we're doing that. We have a huge promotional campaign led by UASL, our Director of Communications and Events, which is excellent and is huge. We are constantly getting our faces, our contributions, our facilities out there through our various promotional campaigns. And they're big campaigns that we have, not just in Kazakhstan regionally, but internationally increasingly too. More can be done, of course it can, but we're doing that. And we have managed to have our court and arbitration centre included into the dispute resolution clauses of more than 5,500 business contracts. And that is included with the likes of Chevron, Tengiz Chevron in Kazakhstan, and now with NCOC and various other global corporations. And that's a very encouraging sign, because what that does is show to the rest of the world, or at the very least our Eurasia region, that our facility is now trusted. If we're being included in operations contracts of 3 to 5 years duration, and indeed now I'm told, and it's public knowledge, I understand, that 25 plus years subsoil use contracts will include the option of using the AIFC Court or Arbitration Centre. That's very encouraging, that we've achieved that level of trust and confidence in our dispute resolution protecting investor rights system already, and I expect that to continue for years to come.
Thank you, Chris. The third question, does it matter what is the value of a dispute for the AIFC Court to have jurisdiction to consider the dispute?
No, it doesn't. So the court and the arbitration centre are here for all commercial or civil disputes. I should have said earlier, and I didn't, but the court does not consider criminal law matters. It does not consider so-called administrative matters. That is not the administrative in the sense that one might understand in the English and Welsh system. The court does have some limited, effectively, judicial review powers of actions taken or decisions taken by other bodies of the AIFC, including our friends at AFSA, although that hasn't been tested yet in our facility, no doubt because AFSA is known for conducting itself in the very best international way, and it's not been necessary yet. But that time will come, as it does with all international financial centres, and our court will be ready, willing and able to assist when that matter arises.
Okay, thank you, Chris. What is a judicial mediation? How does it work at the AIFC Court?
Right, so I'm sure everyone is, most people will be familiar with the concept of mediation. So it's different from arbitration. It's different from typical court litigation in various ways. One way is that the process tends to be more flexible. The parties can choose if they wish to have any particular rules applying or no rules. The IAC has its own mediation rules, and those are being used frequently by parties in disputes at mediation proceedings at our IAC. But the parties have maximum flexibility. We have, throughout our IAC, have been a part of mediation dispute resolution that has been done as quickly as 1.5 hours or 2 hours, and from parties being physically located anywhere around the world simply via technology, via their mobile phones. So the system is extremely flexible. There's typically, there is a neutral, independent third party or facilitator who goes between the parties. It depends on the strategy, if you like, or the technique that the parties or the mediators wish to pursue in every given mediation proceeding. But you typically do not have a courtroom set up or an arbitration room set up. You have a more informal process. And the idea is to resolve the disputes as amicably as possible, so the parties come together. They don't lose face as much as perhaps they might do if they're in a more confrontational dispute resolution setting, such as with arbitration or a court litigation instance. So we provide all of that, and it's been heavily tested and successful so far.
Okay, Chris, so there are only 5 minutes left. So last question. What plans are in place for the future of the Court and Arbitration Center?
Thank you. Yes. So the Court and Arbitration Center, as I said a few times now, are coming towards the end of their 4th year of operations. And we've put in place a 2025 vision for both the Court and the Arbitration Center. This will be publicised soon. And the idea is that both the Court and the Arbitration Center, while separate and independent legal entities, they cooperate very closely together. They're not competing with each other, they're cooperating. And a lot of centres, in my experience, get that wrong. Yes, some healthy competition is useful, is good to raise standards and all the rest of it. But we focus very much on, there is some competition, but it's mostly cooperation, working together to provide a one-stop shop for dispute resolution for parties or investors in disputes. That will continue. As a part of the 2025 vision, we're focusing very much on stability and continuity. We want investors to know, and I'm happy to make this announcement right now, that the trust that you have already, in some instances, given this Court and Arbitration Centre will continue for many years to come. There will not be, we expect, a sudden change of judges or arbitrators. The personnel will remain the same, and that's very important because we've done all of this development and building the trust and confidence and successfully resolve disputes now. We want that to continue. We want you, the investors, to know that this Court and Arbitration Centre are here to stay for the very long term. We're also focusing on growth. So we're always focusing on growth every year. We want to raise our standards. We want to learn any lessons learned and make improvements in our services provision. And we do that every year. But from next year, we will be looking at rolling out additional services, and we're looking at further expansion of both the Court and Arbitration Centre user function throughout the entire Eurasia region. So we want our centres to become more internationally recognised. Thirdly, so we're working very hard towards that through various initiatives to bring us in the minds of investors to a higher international level, not just in terms of the quality of justice that we provide at the AIFC Court and IAC, which has to be as quick and cost effective and reliable and trustworthy as possible, applying, as I said many times now, the highest international standards of the rule of law, but it needs to be accessible as well. And we want more people to use this facility to protect their investor rights.
Okay, Chris, thank you for your speech and thank you for these questions and answers to these questions. So before we close the proceedings, do you have something to add in the end?
No, only apologies again for the IT glitch, but I'm glad we got through that. And the Court and Arbitration Centre are open. We have our staff on the premises, and if people want to visit, if they happen to be able to, and it's safe for them to do so, they happen to visit Kazakhstan, please let us know. We are available 24/7, and we're here to assist parties who are interested in what we do and who may want to use our facilities. We do have various public engagement initiatives coming up and opportunities, so we do encourage very close cooperation training of the Kazakh student population. We give various lectures at the universities in Kazakhstan and elsewhere throughout the Eurasia region. We will be having our annual mooting competition, I think, which happens this month, and that will be public knowledge very soon. And I believe we've got as many as 10 teams this year, which is very encouraging. That competition is now in its 4th year, so it's really become a firm part of the institution, if you like, of the AIFC Court and IAC. So we're very much looking forward to that. Other than that, we look forward to our further public events coming up between now and the end of this year. And then, of course, there'll be a full-on program, as always, next year and for the foreseeable future. So thanks very much for this opportunity to talk about what we do. And we look forward to engaging more with the investors in the coming months and years.
Yeah, thank you, Chris. And we can close the session now. I would like to thank all participants for joining this webinar. I hope it was useful for you. And we thank Astana Financial Services Authority for organizing this annual event. Please stay online. The next session is starting soon.